and welcome to Legally Speaking with me, Tarun Nangia. This is an important show where we're going to discuss Justice Suryakant as Chief Justice of India, observations, challenges, and milestones yet to be achieved. And I remember the last time we did such a show with Justice Arjun Kumar Sikri and Dr. Abhishek Manu Singhvi was when Justice D.Y. Chandrachud was the Chief Justice of India. He had also a long tenure, and now we do this for Justice Suryakant. He has finished 8 months and 6 months more to go. That's about 180 days more to go, which is a long, long time. And that is what we're going to assess what he sort of did in the past 8 months, and of course, what is sort of expected and observations over the next 6 months. I want to first formally introduce my panel. I want to introduce Justice Arjun Kumar Sikri. As you all know, he's India's leading arbitrator. He's a sitting judge at the Singapore International Commercial Court. He served as a judge of the Supreme Court of India, the Chief Justice of the Delhi High Court, the Chief Justice of the Punjab and Haryana High Court. And currently, as I said initially, he is known as a leading arbitrator. Good to see you, sir. Thank you so much for your time. I have with me Dr. Abhishek Manu Singhvi, clearly a man who doesn't need an introduction, be it the legal fora, the political fora, or the social fora. But allow me to give a formal introduction. Dr. Singhvi is a fifth-term sitting member of Parliament. He is an eminent jurist. Formerly, he has chaired the Parliamentary Standing Committee on Law, Home Affairs, and also Commerce. He is a member of the Apex Committee of the Congress Party, the Indian National Congress, which is the Congress Working Committee. He also served as the Additional Solicitor General of India, also serves as a senior national spokesperson of the Indian National Congress. He's also the chairman, I think from the past 1.5, 2 years, of the Congress Department of Law, Human Rights, and Right to Information. In addition, of course, he's a prolific author, and of course, in the media, he is well known. Good to see you, and thank you so much for your time. At the outset, Dr. Singhvi, and I know we have discussed this earlier, you have a certain view on tenures of Chief Justices, and you said it when we did this show on Justice Suryakant before he took over as Chief Justice of India. As we sort of discuss the challenges, milestones yet to be achieved, and observations, what is your sort of a 3-4 point of view on Justice Suryakant's tenure?
There are many heads we can discuss, and I'm sure it will unravel as the discussion progresses. But if I was asked to, let us say, address 3 or 4 heads at the outset, as you asked me, of course, the bugbear of Indian Chief Justices is that, a tenure of 14 months or even 1.5 years is extraordinarily long by current standards. It's given to very few, a chosen few, who have generous tenures. And therefore, if you were to apply the strict test of looking at achievements beginning and ending with their tenure, that would be unfair because the tenures are very short. And secondly, as a preliminary point, I would like to say I have told many past Chief Justices and to-be future Chief Justices that they must consider at least 5 of them, the current and the 5 coming in after him, to consider having what parties call a CMP, which is not necessary for the judiciary to call it the same thing, but they must have a common minimum program, agree to disagree on A, B, C, D, 10 issues, but agree to agree on 5 core issues, agree to agree on 10 core issues, and hand over the baton, because your tenures are so short that a common minimum program, or I would better call it a 5-year plan, as we used to have in the old days, or a 10-year plan going down to Chief Justices from 2022 to 2032, for example, would do a lot of good. And you must then stick to it without mid-course correction. You will find the synergy and the results working. And I've said this openly to Chief Justices, and some of the younger ones coming up now, I'm sure, are going to try to do that. Now, you have 4 broad heads before we go into other things, and we can then hear Justice Sikri, and then we can go to other heads. One, I find Chief Justice Suryakant extremely grounded, rooted, earthy, a very pragmatic man, and a very real life grassroots person. Now, that might sound a general opening comment, but that is very important because it comes from a background of his a first generation lawyer. That's not very common in law, rising to the Chief Justice. Not a first generation judge, a first generation lawyer. And, then starting at the district court level. In fact, I was intrigued by hearing that he did his LLM, his thirst for getting degrees and working hard and getting education, after becoming a high court judge, which is quite extraordinary. And of course, the youngest AG and all that. So, all this makes it very good because he can realize the common persons and the common problems at the common level, at the procedural level, at the real level, at the doorstep delivery level. That's number one. Not all chief justices, with the best of efforts, can have that practical touch. The second thing is something I have been advocating for a long time, and I'm very, very happy to have learned recently that he has picked it up, although without attribution to me, and I'm not looking for attribution. A lot of these cases, 20 years old, 15 years old, 10 years old, give us all a bad name. It gives each high court a bad name. I'm sure Justice Sikri has been in high court. There are some, you've got 25-year-old case, you've got a 20-year-old case. But actually, these cases are few and far between. They're not very large in numbers. Now, apparently, the Chief Justice of India for the Supreme Court has at least proposed officially, I don't know when it will start, but I'm sure it will start soon, 3 or 4 special benches dealing only with the older cases, specifically 5-year, 10-year, 15-year, and 20 years. Now, if they stick to this, and I'm sure they will, this will be very, very good because there are not that many, and the Supreme Court can clear off at least the over 10-year ones very quickly, and maybe the over 5-year, between the 5 to 10-year band also. And that makes it a very good thing to say. It gives a bad name to the Supreme Court, gives a bad name to every high court in the country. That has been proposed. I hope the judges cooperate in having those benches stabilized. And I think a couple of years of that work will give you a very good, new, clean look. My third point is that he has now presided over successfully for the first time, and though it was in the offing. And mind you, I don't agree with the fact that you must have working vacations. I believe our judges work very, very hard. It is only the uninformed and even possibly the ignorant who make the allegation that the judiciary is enjoying life and not working hard. That is not true. But now that we have this culture of lesser holidays, he has presided over a fairly successful PWD phase, partial working days, 5 benches, at least 4, but frequently 5 benches for 5 days a week, right through June, and not counting the 15 extra days put in directly by the Supreme Court's, whatever, 18 benches up to May end. In fact, the irony was that the lawyers and the litigants were found wanting because many of them started seeking adjournment because the old cases came up. But it's good to see that now that it's part of the fashion and culture to work in the summers. You had a constantly working Supreme Court, and that he managed where he himself sat for a week, and I think he managed the whatever there might have been discomfort and dissent and whatever, but it went fairly smoothly. And I think this will be a very good clearance methodology for the Supreme Court. And I don't see any reason why eventually, although I know that many high courts are feeling disgruntled about it, they'll be forced to emulate this. Personally, I don't agree with this that you should be working all the time. But then, nevertheless, high courts will be forced to emulate this over time. And my last of the 4 points, which you are asking at the beginning, and we'll come to others, is the point about apparently Justice Suryakant. Everybody has talked about it, but I find he's the only Chief Justice in the recent past who has announced and declared a blitzkrieg, a war through mediation, not on mediation, but through ADR. We have done a program with you on that. He has tried to give ADR center stage not only by way of speeches, not only by way of declaration, but practically. Every speech, in his court, it is almost impossible to resist mediation. But it's not his court that I'm talking about because he's only one court. Across India, he has given that a great impetus. We forget that we have a state-of-the-art shining Mediation Act of 2023. I had the privilege of speaking at Pepperdine in California. It is called the Mecca of mediation. And there they were very laudatory and very positive, saying that you have a brand new state-of-the-art act. And this can lead to a revolution in mediation. Of course, as usual, the bureaucracy lets you down. The rules of that Mediation Act are not yet notified in many parts. But Justice Suryakant is pushing hard. He has given numbers. He has given the number of mediators he wants to fill up the gap. He has tried to. So I think this will have an impact by the time his term ends. At the moment, I'll stop at 4 points and we'll discuss more.
Thank you. Thank you for that four-pointed opening comment on Justice Suryakant. Now, before I request Justice Sikri to start his opening comment, let me give a disclaimer or something that I know that Justice Sikri has earlier worked with Justice
stuck. Some issues.
I'm glad that you also can't hear it.
When he was Chief Justice of Punjab.
I think you start this segment again, Tarun. You're completely stuck for 2-3 minutes.
Some disclaimer you were saying, and thereafter we couldn't hear you.
Yeah, so I wanted to share that Justice Sikri has served alongside Justice Suryakant in the Punjab and Haryana High Court, as Justice Sikri served as the Chief Justice of the Punjab Haryana High Court. So he knows him from those days when both served in the same court. Of course, that's what I wanted to share for the larger audience. Over to Justice Sikri for his opening comment.
Yeah, thank you, Tarun. And I think Dr. Singhvi has laid the foundation so well, giving the narration about the achievements of Justice Suryakant, and rightly pointed out about his personality, his background, a grounded person who is a grassroots person, etc. And therefore, he has been able to see the judicial system, legal system from 360-degree angle, if I may say so, because he understands the plight of the common people who come to take justice from the courts, that their cases should be decided. So it augurs well when we come to access to justice for marginalized section of the society. So therefore, he can resonate and he can clearly understand what are the problems they are facing at ground level. Not only textbook studies about, those people. Other thing which he said was about the tenure, and in that tenure, CMP. I think Dr. Singhvi will have to afterwards take a call on this, because I said so few years ago on Tarun Nangia's one of these shows only, and about it was again about one Chief Justice, and we were talking about the tenure, and I said that look, when the tenure is not enough for a Chief Justice to bring many reforms, why not there is a committee of 4 or 5 successive Chief Justices, and I use the term CMP there. So we'll have to see whether it is me who coined it first for judicial, this sort of collegium of Chief Justices, or you did. Anyway, that
great minds think alike. So independently we did it.
There I agree with you. Okay, thanks. And see his other what he has mentioned about old cases and ADR and the partial working days, etc. So this I'm not going to repeat. What I will say here, of course, on ADR, I'll say something. You see, what we have to keep in mind. First thing is that there has to be access to justice to all. We always talk about and speedy justice, cost-effective justice. Yeah, those big multinational companies who can pay Dr. Singhvi the kind of fee which he charges. I'm not talking about that, but common people, for them, it has to be.
I know about your arbitration fees also now. Go on, please.
So, but then it has to be cost effective. And keeping that in mind, and when the areas are mounting, particularly, you see, we have seen pre-COVID period was where either the cases in the country were almost stable in the sense, of course, there was I mean, areas of we used to call 30 millions, but for many years it remained 30 millions. And if there were almost 10 million cases, 9 to 10 million cases which were filed every year, that many cases were also disposed of every year. So therefore, areas were not increasing. Yes, it seems to be a very big figure. But then, I mean, when there was so much of disposal, so new cases in the pipeline also are there. So if you remove that, we could still manage. But what is happening in last four, after post-COVID particularly, the cases, the areas are mounting. It has at all India level, it has gone up to almost 58 millions. Even in Supreme Court, it is increasing progressively. It was 60, 70,000. It is figure is almost now going to touch 100,000. And in the high courts also, it has increased substantially. So therefore, what is, yes, we have been discussing about mediation. Mediation was introduced in our CPC by amendment in 2002. It has been very well ingrained in the system. It has taken off very well. But then, if you see the success thereof, except in few states and few districts where it has done really well, it's not that we have been able to disseminate the idea of mediation throughout the country at national level. But what he has understood is, and which is right, that look, we cannot solve the problem of arrears in the courts only. So we have to have parallel system. And that parallel system, ADR, which is, according to him, he says it is not an alternative. And he has said that it is an integral part of the judicial system or legal system to reduce the arrears. And so ADR includes both, of course, arbitration and mediation. But then he has also raised those concerns, and rightly so, that in many ways, arbitration is also mirroring what is happening in the courts. These are his words. And therefore, mediation has to play a very, very important role. And when he came, he started this crusade, that mediation 2.0, and it has to be mediation for the nation. I think that's the slogan which he gave. And the good thing is that in these 8 months, what we are talking, he has not only talked or given, he has not only given various speeches on mediation and how there are so many, I mean, steps which are taken in order to make mediation an integral part of the judicial system. And those measures which have taken are really commendable. I think if he is able to, and if we take the example of US, in 70s, US also had the same problem which we are having today. Their cases were lingering. It used to take so much time. And it is the mediation which solved the problem. And today, 94, 95% cases are, even in last 30, 40 years, it is happening. And even today, 94 to 95% cases are decided through mediation. And the courts are able to bear the burden of rest of the cases very easily. And I think that is his dream. And we hope that he lays such a strong foundation for mediation to a movement that it ultimately starts yielding results in near future. And that's the only way we will not only be able to reduce the areas, but as I have always said so, and way back in 2006 or 7, I had authored one article or essay on this, that mediation is the best form of access to justice by giving statistics and data and real-time stories about the mediation. And therefore, I think his crusade for mediation, his commitment for mediation is something which has to be lauded. That, in addition, I would say, and we can discuss about these in detail later, that look, the reforms, and whenever we call about the judicial reform, there are two or things which have to be kept in mind. Over a period of time, and right from 1950, when I mean we gave ourselves constitution and the Supreme Court was established, the Supreme Court has really done remarkably good job. There was a time, and I still say that even now, that it has the trust of people. But then there was a time where it became one of the most fearless judiciary, one of the most independent judiciary in the world. And that is why it used to be said that the Indian Supreme Court is the strongest or most powerful court in the world. And this is because of PIL and other things, access to justice, and all those measures on judicial side which were taken. But again, coming back to that, which it is very important that in order to have that, kind of impression in the minds of public, coupled with that is Indian scenario, which had been up to now, say up to 1990 or till this new millennium when it started. But what happened from 1991 onward, and thanks to Mr. Rao, our Prime Minister, and Mr. Our who became Prime Minister also, and the Finance Minister at that time, who introduced a liberalized economy or globalization. With this, there is another segment of cases which has started. That is arbitration cases, which have now taken the international color, intellectual property, patent cases, etc. And therefore, we have to show to the world at large as well that the Indian judiciary is well equipped to deal with these matters. So therefore, trust within India, trust for the world at large, which is very, very necessary. And on that basis, the kinds of reforms which are needed and which have been, some measures have been undertaken and some measure need to be undertaken, which we'll allude to. But the two kinds, I would say, one is administrative reforms and other is judicial reforms. When it comes to administrative reforms, and for a Chief Justice, it is not only in the Supreme Court, but for the entire country. And so therefore, there has to be expeditious disposal. There has to be a category of cases which are to be given priority. And there have to be then, for this proper, that is why I said ADR mechanism, and at the same time, proper court management and case management, which is required and which is in most of the countries, we have to do that. And other are functioning of the court on judicial side, where and in administrative reforms, I'll include infrastructure as well. When it comes to infrastructure, the reforms in the registry, the reforms as far as the listing process or procedure is concerned, in technology, whether it is computerization or AI, the training of the staff, etc. All those things are needed. And on that, if I may say, and as I said, the capacity building of the judges also to deal with all these kinds of cases. So he has done, if I may say so, insofar as listing of the cases, mentioning accountability as I said, he has brought quite a new measures he has introduced. If you remember, on the very first day of the working day, he said that no oral mentioning, and every case will be listed within 1 or 2 days. So it's not a court anymore where cases to be listed after 15 days, 20 days, and sometimes you have to mention it again and again. So that has not been happening. Fresh cases are now listed automatically, and liberty is given in respect of bail and anticipatory bail, habeas corpus, or death sentences cases that you can mention. So therefore, he has been conscious of this fact also, that I will not rule out mentioning totally. Then senior counsel may be lost to Singhvi and others. The senior counsel cannot mention, so some the opportunity is given to the young generation to mention about this. Then advanced copies of bail petitions which reach nodal officers, etc. All those measures which he has taken. About the that has already been said by Dr. Singhvi, the old cases, the benches which he has created on the opening 4 benches here, and he has asked the high courts also about that. But I'll add the two cases of that, I think 7 bench and 9 bench of Sabrimala, and I think both were 9 bench cases. That Sabrimala, yeah, 9 bench Sabrimala, and on industry, definition of industry is pending since I think 80s or late 80s or early 90s. I remember I had filed a petition as a counsel at that time. So all that, so both are now, judgment may come anytime, and the constitution benches these kinds of matters which are taken. And other thing on I would say, as far as some the reforms are still needed, but he has tried to streamline the process as far as bail and personal liberty access to just I mean system cases are concerned. And he has also tried a lot and is now talking about the infrastructure in the judicial district, district judiciary. And if I may say so, Judicial Infrastructure Advisory Committee has been set up. It was set up in May 2026, and allocation of 40 to 50,000 crores of rupees, which he has demanded. The committee is going to give the report soon. It is expected that and that is the timelines, that by August it should be given, and therefore all kinds of infrastructure which is required at district court level should also be there. And there I would say that conception of infrastructure is granular and lawyer facing as well. And in while this inaugurating one district court complex in Chandigarh, he had inaugurating multi-level parking, where he had mentioned about it. So he is concerned about I would say common facilities which are to be given to lawyers as well. And another thing on which he is again taking steps is about the appointments. We have seen that many times when the appointment, when even the names are recommended, they take a lot of time. Of course, at Supreme Court level, appointment of judges, it is not happening, but at High Court, it has become a perennial problem. So he has tried to look into this problem as well. So these are, I would say, some of the very, very interesting and very, commendable steps which Justice Suryakant has taken up to now.
Thank you. Thank you for that opening comment. And you covered some aspects in detail for the audience. I'll go to Dr. Abhishek Manu Singhi for the second part, where he will share with us his suggestions for Justice Suryakant and also milestones yet to be achieved. So over to you, Dr. Singhvi, for this.
So we have discussed a lot of issues, and obviously I'm not going to repeat any of them, whether discussed by me or by Justice Sikri. All of them go into a box where he's pushing hard, right direction, good momentum, and we only hope that the momentum is carried on, because without the CMP, of which both of us have advocated very strongly, the momentum lags. What happens is each Chief Justice tries to leave his own stamp, and then it becomes too much of zigzag and mid-course correction. That should not happen. In addition to what has already been said, let me add a few more things, including the challenges you're talking about. Now, this is a good example of the CMP, what I'm now going to mention. It is not any one Chief Justice's achievement. I looked up some figures, and when you work together on this, it makes a difference. On this e-courts and, putting technology to work for the courts, there has been a consistent push by several past Chief Justices, be it Justice Chandrachud, be it other Chief Justices, and it is an ongoing push by Chief Justice Suryakant. The figures are very impressive. The other day, people in USA and UK were saying that we have absolutely no such VC courts, even 1/100th of your capacity. Now, we can excuse England, but America is a very big country. It's a federal country. They said that, look, we struggle sometimes, even when necessary, to do any VC hearing. I got these statistics which impressed me a lot, that we have conducted just under 4 crore VC hearings. Of course, they can be of indifferent quality. Sometimes it's not that good, but 4 crore VC hearings is not a small achievement. That's one of the great good benefits of a bad curse, COVID. 4 crore VCs. Now, we have had 1.03 crore cases already e-case filed. Namely, these are not physical filings. That's not a bad start. Of course, it will grow. The most impressive was 637 crore pages of court records digitized. As I said, these are all examples of the CMP. This is no one Chief Justice's job. They started digitization some time ago, and it's carrying on apace. 637 crore pages of records digitized. Maybe by the 2 or 3 next Chief Justices, you would have had all relevant records digitized. That's a great achievement. Space, infrastructure, dirty papers, lost files, all that, changes. And of course, Chief Justice Suryakant in particular has pushed for court complexes. 3,240 new court complexes with a VC facility, with a virtual, the courtroom itself would be fully virtualized. 1,272 prisons where that facility for the interface with the courts, etc., etc. Then there is a second aspect which is less talked about, which perhaps Justice Sikri can't talk about so freely, but I will. Every Chief Justice, a lot of Chief Justices are individually can be very good, very able, very outstanding. But the ability to carry the flock together is an element which we tend to forget. A Chief Justice has to have that additional ability, not only being competent himself and good in his administrative and judicial work, but the ability to carry the flock. There have been unfortunate cases with very bright Chief Justices, but not an ability to carry the flock together. That makes a difference. I find that in Chief Justice Suryakant, of course, in a diverse country like India and in large courts, it's never possible to carry everybody together. But by and large, I think that collectivity, that collegiality, that consensuality, etc., should be very important, non-quantifiable features, which every Chief Justice, he can make a difference. I find that he's doing pretty well in terms of giving judgments, although there have been Chief Justices who have given more. But, I had the privilege of assisting the court in 9 judges of the lead council, Sabrimala and all the religion cases. They took a lot of time there. And he's now coming up with the Constitution Bench series of cases shortly, again next month. So he's trying to attack them. Although I must say that the challenges remain. Now, the challenges are very peculiar in India. With all this talk, with all the seminars, with all the proclamations, the sad truth is that the structurally embedded problems are not changing much in India. And I don't see that that's only the problem of any particular Chief Justice. It's a problem which somehow you have to give an electric shock to change the system. I identify 4 very sad and fundamentally structurally embedded problems which should shock any Chief Justice and any system. And they are the real challenges for anybody. And they haven't changed much. One is, as already Justice Sikri has said, in the middle of all this talk, we have exploded from 3.25 crores to 5.5 crores. He says 5.8 crores. I say 5.5 crores. Hardly makes a difference at that level. This is an enormous, humongous, terrible figure in the middle of all our seminarizing and preaching and sermonizing. We have jumped 2.5 crores. Now, the reason doesn't matter. You can't blame it. By the way, you can't blame it on COVID fully. COVID is long over. The 20 to 22 phase, yes, but this has now become a structurally embedded problem. You need a war of a very different kind. 1/3 vacancies at almost every year after independence till today. In 80 years of our republic, you throw a stone at any point of time, and of the 1,100 odd High Court judgeships, roughly, of course it varies a little bit, 1/3 are always vacant. This is a structurally embedded problem. 1/4 of all our district courts are always vacant. Better than the High Courts. But how do you manage a system of 5.5 crores today with a 1/3 and a 1/4 figure which I'm giving you? I, in fact, don't call it a criticism. I don't call it a challenge. I, for the life of me, can't think of a quicker way of doing this. And unless somebody really, really gets down to it in a very serious way, in a concerted way, these are structural problems which will remain. Also, the problem of our constitution bench is pending. That's a peculiar Supreme Court problem. We do manage a few every year, but it is nowhere near the numbers required because they take time. And, we now, of course, have 37 judges, but I don't know how we're going to push it on. So these are issues which I hope and trust. I'm not addressing this to a Chief Justice, but a succession of Chief Justices will apply their mind to, because there is no way in which India can be called an avant-garde country judicially if by 2030, which is still 4 years away, you do not reduce these three structural features of 1/3, 1/4, and 5.5 crores. That's, I think, the saddest part of the whole system. That's the saddest commentary on our system for any Chief Justice.
Thank you for this intense commentary on the state of affairs and your suggestions. I wouldn't call it in a lighter vein, but the little bird told me a few days ago that we don't have houses for the new judges that are going to be appointed. And though it may sound not too serious an issue, but someone who's shifting from his state, it could be an issue staying in guest houses and all. There's no houses for ASGs also. But that's a debate for another day. I'll go to Justice A.K. Sikri for his suggestions and milestones to be achieved answer. What do you say?
Yeah, I think I wanted to touch on these three aspects, which Dr. Singhvi has explained very lucidly. And as I mentioned earlier, also areas are one such problem. And for reducing these areas, apart from ADR, which we say, you need more judges. Now, on the one hand, we say that our judge population ratio is one of the lowest in the world. It may be 25, 26 judges per million. In comparison with US, UK, I think which is 150, 125, and even a country like China, it is, I think, more than 300 per million. And so therefore, it is such low figure. So we need more judges. But irony is what he has pointed out, that even the sanction strength which is there, 1/3 and 1/4 is not filled. One way is that, look, there, if you're in judge's case, it was very clearly the procedure which was laid down was that 6 months before the vacancy arises, the Chief Justice of the High Court will recommend. And so that the process starts, the ideal picture which was painted in that on those directions was, if it takes 5 to 6 months, that is the process for appointment. And if the vacancy is going to arise even in future, 6 months before that, you start that process, so that by the time the judge concerned is retiring, new judge takes place. I mean, instead of that kind of rosy picture which was painted there, here vacancies are there. And first, it is the problem in the, I'm very frank in saying that in the collegiums, in the high courts itself, those, in spite of vacancies lying for sometime years, and the recommendations are not made. Once the recommendations are made, then at the executive level also, so much time is taken. And now the time taken is much more than what it used to be earlier. So this has to be, if direction is issued, that going by the judgment, all the chief justices in the high courts have to strictly comply with that. There's already direction in the court judgment. So if that is issued and they start doing that, of course, it is not very easy. Many times there are many other problems. Sometimes they say if we start appointing in bulk, we may suffer in quality, and we may not have many persons from the bar who are able to join in one go. Like I remember at one point of time, few years ago in Allahabad, there were, I think, 60 or 70 vacancies at one point of time, or maybe 80 vacancies. Now, if you strictly follow this mandate and send 80 names, naturally it is going to, there has to be some compromise with the quality, which cannot be tolerated. I think it should not be there. So therefore, there's a really a tough, it is a tough tough situation. And therefore, as I agree with Dr. Singhvi, that it is not easy to cope with this and deal with this, but then some measures are required, going by all the kinds of challenges, that how we go ahead with this. There can be these meetings with the executive on that how somebody may come with some kind of measures to hasten the appointment process, etc. That apart, other things which I would say, that as far as Justice Suryakant is concerned, two or three things which come in my mind, which I see are in the other jurisdictions also, and it may not be the time, may not permit me to say so in an elaborated manner, but I will be able to at least touch upon these things. Uh, in respect of constitution matter, the benches, what he has already mentioned. But if in respect of, like we know that as far as criminal justice in India is concerned, it is crumbling. It has to be saved. So therefore, some message has to go to, and some very, very big reformative measures are required, which are at various levels when it comes to the trial in criminal cases, and when it comes to appeals in the High Court, and when it comes to Supreme Court. In Supreme Court, it may not be much of a problem, but still there are many cases, old cases, for which now benches are constituted. So Supreme Court may be able to take, take care of this, but at district court and at High Court level, it is needed. When it comes to Supreme Court, I would say one thing, that all those cases where death penalty is given and they are pending in Supreme Court, in your 6 months' time, you ensure that this pendency is brought to zero, because this is one category which needs real, urgent attention. And likewise, insofar as bails are concerned, I always feel that bails are such matters which should not even come up to the Supreme Court. Why? It should be settled in the sense satisfactory settlement of the, or disposal or resolution of the matters at the High Court itself. But since that is not happening, matters are coming to Supreme Court, and to some extent, some kind of confidence is to be instilled in the public that we are able to deal with this. So these two types of cases, bail matters, and when it comes to Supreme Court, and death penalty matters. And another thing which he should try is not only in the Supreme Court, but in the at the High Court particularly. It can be district court also, but district court I'm excluding for time being, that case management and court management should be introduced, and it should be really followed. If you see in our courts every day, and that includes Supreme Court also, matters are listed where the court is saying pleadings are not complete, this is not filed, and all that. And why these cases are coming up before the court? If I have seen, now I can see from the example of Singapore. I have seen SICC, but I've seen Singapore's court, Supreme Court also functioning, and their High Court also functioning. No such matters come. The matters come before the courts when they are ripe for hearing. And the staff is so expert and trained in that, and even in judicial matters, etc., how these matters are to process. Yes, from time to time, they take the they will take the instructions from the judge from whom the matter is, but that would be on file. And when I say when I'm sitting at SICC at level, the bench on mails, it would come and we'll give the instruction. But then they are dealing with the parties, and matter before will come before us on the day it will be listed when it is to be argued. So it will save so much of time, but then you need this kind of trained your staff. And another thing I've seen in these courts, that and that may be very helpful. Yes, we have the system of court clerks, but then I have seen some of them there are able to even write very good judgments. I'm talking of their judicial officers that attached to Supreme Court, not judicial officers. They are not judicial, but then they are judicial clerks, etc. So you have to have these persons of that caliber. They will be able to take, load of the judges in the High Court and Supreme Court, and the disposal will increase. I'm not saying ultimately the judgment has to be written by the judge. It is not to be written by them. But then the groundwork, etc., what they are able to do, and where here in India we dictate the judgment from A to Z, and it takes so much of time, that would take care of much of the burden of the courts, and the courts will be able to, or judges will be able to, give more time to the judicial work in the court, and will be able to hear more cases. And another thing which if you remember in the beginning, I said that we have to have our, the status of the Indian courts should be recognized, or the merit should be recognized internationally as well. And for that, this domain expertise and benches in that, as I said, when it comes to arbitration matters, it comes to patent matters, and there are other big commercial cases, investment treaty cases, etc., which are concerned, which come to courts. Then there should be at high court level also domain expertise and those judge. Now we are in the era of specialization when it comes to insolvency cases, etc. So we need to have those judges who are really expert in that. And if we are able to create or send that kind of message to the world at large that we mean business. Why? Again, I'm giving the example of Singapore. When it comes to commercial cases, why there's so much faith? I'm not talking of Singapore International Arbitration Center, etc., but in the Supreme Court judges also. Why they are able to send that signal? We are pro arbitration, and when it comes to India, we lack that kind of consistency. We were talking about teamwork, but in the without giving any details in the matters of bail itself, and Dr. Singhvi has been part of, as a lawyer, has appeared before those benches where one judgment earlier is interpreted differently by two different benches. And if he's what I'm trying to say, there is always feeling in the bar and public at large. If there are 15 benches, there are 15 Supreme Courts. If able to, he has already talked about teamwork, and he has said that we are working as teamwork. If he is able to talk to them, that there has to be, of course, each judge is independent. I'm not saying that each judge has to decide the case and the cause which comes before us. But if there is some judicial philosophy, common judicial philosophy, they can agree upon, and the court is projected as one court among people, that again would be a very, very good achievement, even if he's not able to achieve it fully, but substantially if he's able to achieve that. So these are some of the things in my
Point.
mind. I would only say one thing more. I think time has come when our Supreme Court, there's always a discussion whether Supreme Court is a court of appeal or it should be only a constitutional court. Let even if this system remains, I'm not on that, but maybe it's a very, very, I think high sounding, if I may say, suggestion which I am giving, whether Dr. Singhvi likes it or not, I don't know. But there should be some amendment. He as Chief Justice or the Supreme Court can give this suggestion to the Parliament that amend Article 136. And so that at least those cases where local acts are involved, local issues are involved, there the High Court should be the last court. They need not come to Supreme Court unless, on one exception, I would say, the virus or the validity, constitutional validity of the act is under challenge. So those cases, apart from that, a rent matter where it originates under the say rent act of that particular state, why it should 2 or 3 layers in the district court, then the high court also, why such cases should come to Supreme Court at all. So there are many such cases which can be carved out, and if it will reduce the burden of the Supreme Court, at least will not be perceived a court which is court of appeal in every case, as I always say, starting from SC to SC, small cause to Supreme Court. So that kind of situation would not be there. I think these are some of my ideas.
Point well taken, and thank you for all these suggestions. Some very good amongst them. We almost out of time, so we'll take one minute closing comment, and we'll close this show. I'll go to Dr. Abhishek Singhvi.
No, Tarun, I think you need another program because we are now into the realm of actual reforms in arrears reduction. That's a very important topic, and I don't think we have the time for it. All I can say is, partly in a lighter vein and otherwise also, that there are so many other reasons apart from the very, very important ones Justice Sikri has just itemized. And I agree with almost all of them or most of them, including especially the 136, which is more of a question of collectivity, consensuality, and a intention of Parliament together to amend 136 by 2/3. But very in a lighter vein, as far as appointments are concerned, this 1/3 and 1/4 vacancy, especially the 1/3 category, we know for a fact, almost a blindfolded non-lawyer can tell you who are the 10 best lawyers deserving elevation in the 10 high courts or the 20 high courts. We know whom to appoint, and after we identify them, we find reasons to disappoint them, not to appoint them. That's the reality of the Indian political chakra. And let me tell you, the politics of the judiciary will make the politics of politicians blush. Second, I think we have underutilized the ad hoc judges provision. I am gratified that Justice Kaul in a judgment quoted an old article of mine. It's one of the most underused. I don't know of any single High Court ad hoc appointment. I know of 4 or 5 Supreme Court ones, but it's very few and far between. Thirdly, when I was chairman, I'm just giving you quickly anecdotal ones because Justice Sikri has covered them comprehensively. When I was the chairman of the Parliamentary Standing Committee on Law more than 15 years ago or 12 years ago, I made a specific recommendation, which is a repetition of an earlier recommendation, that please dissolve this arbitrage of 65 and 62. A major issue of vacancies, a major issue of a lot of other negative practices. And there is almost unanimity of it. Nobody criticizes that, but nobody agrees. I got some strange suggestions that yes, it's a good idea, but you must then have Supreme Court judges consider. Why not have 67 for Supreme Court judges? That's the kind of response you get. I have never for the life of me understood this arbitrage for a High Court judge leaving at 62 and a Supreme Court judge at 65.
But there it is the Parliament which has to step in, not the judiciary.
Yes, but I mean, there is, you're right, Parliament, our Parliamentary Standing Committee report recommends that in writing. But somehow, bureaucracy opposes it sometimes, some section of judiciary also oppose it. It's not that they don't, bureaucracy mostly. And ad hoc judges, and I think the fact that we all need to get together into a holistic kind of module. We are still very, very, episodic and differentiated and broken up. We are not functioning collectively. But anyway, this is a topic for a discussion separately as to
we'll come back to that soon. I'll go to Justice Arjun Kumar Sikri for his the last comment on the show today, quickly in a minute.
Yeah, in a minute, I would only say that Justice Suryakant has performed well up to now. He is a person who, doesn't only mince words, but tries to take action also, which he has said so many times. And he said in UK as well, when it came and one question was put in June about the gender representation in judiciary, and he said, and we saw Justice Mohana appointed, and so therefore he believes in action. That is really good thing in him, and up to now he has taken various very, very good steps in this direction. We hope that he carries those further, and I'm very sure we have given some suggestions, me and Dr. Singhvi, going by his intellect. These may not be new things for him. He knows about this also. We are just reminding him that if he is able to do something in that direction as well, and I hope personally that he ends his tenure with glory and appreciation from all sides.
Thank you, ladies and gentlemen. Thank you. I want to more than that thank the country's leading arbitrator, Justice Arjun Kumar Sikri, the country's leading counsel, Dr. Abhishek Manu Singhvi, eminent jurist, sitting MP. Thank you so much for joining us on this one. This is a really special show, and I appreciate and thank you that you could make time for this. Justice Suryakant, observations, suggestions, and milestones yet to be achieved. Thank you so very much. Thank you.